I'm Matthew Robinson, Senior Associate at Dundas Lawyers. Dundas Lawyers is an award-winning corporate technology and intellectual property law firm that also passionately litigates in these areas of practice. In this video, we discuss the process of counterclaiming in civil litigation with reference to the Uniform Civil Procedure Rules, also known as the UCPR. This video broadly explains what is a counterclaim, when and how a counterclaim can be made, and the traditional requirements for a counterclaim. So what is a counterclaim? A defendant may be able to take action against the plaintiff based on the same facts which relate to the original proceeding. While the defendant is still defending the initial action, Rule 177 of the UCPR permits them to file a counterclaim in the same proceeding. Rule 175 of the UCPR states that a counterclaim has the effect of switching the roles of the parties, where the defendant becomes the plaintiff, bringing the counterclaim, while the plaintiff then has to defend the allegations made in the counterclaim. The point to remember is that the allegations must arise on the same facts which first gave rise to the proceedings in the first place. Let's look at an example. A plaintiff sues the defendant for damages after terminating the contract. However, the defendant can file a counterclaim in response because they believe the termination is wrongful and gives rise to a breach. A counterclaim is different to a set-off. A set-off is a defence arguing that the amount claimed by the plaintiff should be reduced by an amount already owed by the plaintiff. Subsection 2 of Rule 173 states that a set-off can be treated as a counterclaim where the amount owing is greater than the amount claimed. So when and how can a counterclaim be made? In summary, a party must file a counterclaim after the plaintiff files their claim with the defence within 28 days after the claim is served, and the initial proceeding must still be on foot at that time. When we say on foot, we mean that the plaintiff is still maintaining their claim. If they withdraw it, a defendant cannot counterclaim this. For example, in the case of Tom v. Fuller, the defendant was barred from filing their counterclaim because the plaintiff had discontinued the proceedings. However, pursuant to Rules 183 and 311 of the UCPR, if the plaintiff discontinues proceedings after having filed a counterclaim, a defendant will not be affected. What are the additional requirements for a counterclaim? A defendant must file their counterclaim with the appropriate court and in the correct form. For example, in Stubberfield and another v. Whitman, the defendant was facing proceedings in the Magistrates' Court and their counterclaim was dismissed because it exceeded the monetary limit of that court. As for the correct form, the defendant must lodge a defence and counterclaim using Form 18. Remember that this means the defendant not file a straight defence using Form 17. There are many other issues to be considered when filing a counterclaim. If you're looking for a proactive lawyer to advise in a proceeding, please don't hesitate to contact me on 3221 0013 for a confidential and obligation-free discussion. Thanks for watching.